guilty to be charged in the information. On the fleeing matter, the state would dismiss the recklessly endangering safety count and recommend 5 months in the House of Correction with work release privileges.
Before I look to defend, so count one you're saying would be dismissed?
One second.
Count one was second degree recklessly
Correct.
endangering safety.
Dismiss.
Count two is the fleeing and eluding an officer, $10,000, not more than, I think, 3.5 years.
Correct.
Okay.
So I would move to dismiss count one upon acceptance of the guilty plea to count two.
Okay. Now, counsel, is that your understanding?
Yes, that's my understanding.
All right. Mr. Newell, have you heard what both attorneys have said? Okay. Before I can even ask what your plea is, certain things have to occur. First, as count number one, consistent with actually accomplishing what's been stated by the attorneys, I'm in order that that count be dismissed. And that leaves us with count number two, where they're charged as fleeing or eluding an officer. The maximum penalty there is a fine of up to $10,000 and or confinement for imprisonment for not more than 3.5 years. Now, that's divided between a period of initial confinement and a period of extended supervision. Do you understand the maximum penalty? Next, the state must prove each of the elements of this offense, fleeing and eluding, beyond a reasonable doubt. And the elements are as follows, and your attorney has been kind enough to submit the 2630 jury instruction. First, the state must show beyond a reasonable doubt that you operated a motor vehicle on a highway after receiving a visual or audible signal from an officer. You understand that element? Next, they must show that thereafter you knowingly fled or attempted to elude that police officer. Do you understand that? All right, we've gone through the elements and the maximum penalty. I now do ask to the single charge in count number two, what is your plea? Are the facts contained in the underlying criminal complaint as to this offense only, are those facts correct? Is anyone making you or forcing you to plead guilty? Said differently, are you doing it of your own free will? When you enter this plea, you give up your right to a trial by jury where the verdict or decision of the jury must be unanimous. Do you understand you're giving up that right? You have a right to remain silent. No negative inference can occur as a result of remaining silent. But even if you remain silent and there were a trial in the matter, your attorney could ask questions of any witness who testifies against you, and your attorney could call witnesses on your behalf. You're giving up these rights. Do you understand that? Next, the burden is on the state to prove your guilt if they can beyond a reasonable doubt. Here, however, you've told me you're guilty, and you've told me the facts in the complaint relative to this charge only are true. That would provide a basis for me to conclude beyond a reasonable doubt that you're guilty. You understand that? Knowing that, you still wish to continue with your plea of guilty to this single charge. On your behalf, counsel submitted a plea questionnaire and waiver of rights form as well as an addendum. Have you had a chance to review these documents? Is the data that's been printed into the forms true? For instance, it states as to your age that you're 34, is that correct? It also indicates that you have completed 12 years of schooling and have your high school diploma, is that true? On the plea phase only, is there anything more either attorney wishes in the record? First district attorney.
No.
Same opportunity, defense counsel?
Oh, yeah.
All right. Based on the record before us, I make two findings. First, I find that your plea of guilty to the single charge in count two. I find that that plea has been entered by you freely, knowingly, and voluntarily. Secondly, based on the entire record, not just your plea of guilty, but the entire record, including the facts contained in the criminal complaint, I do find your guilt has been established beyond a reasonable doubt, and therefore I do find you guilty as charged in count two of fleeing or eluding an officer. Now, the remainder of the hearing, I think, is much less technical. The focus really is on what should be done. My understanding from the attorneys is you wish to proceed to sentencing. Is that correct?
Yes.
All right, we'll do so. I'll look to all parties, but I'll begin with the district attorney and ultimately look to you, sir. District attorney.
Judge, it starts back on December, well, it starts and ends on December 11th of last year. The police had a search warrant. The defendant was the target of that search warrant, the suspect, if you will. And ultimately, when they did the search warrant in the residence, they found some contraband, things of that nature. That's more of the setting. He's not charged with that. He's charged with fleeing. But the police see him in a car outside of the residence. It's a blue Dodge Charger. And they activate the emergency lights and sirens to conduct a stop of the defendant. He starts driving in reverse, going about 35 miles an hour in reverse against traffic, nearly colliding with several parked and moving cars. For those of us, obviously all of us who've driven for a long time in movies, it looks easy. James Bond drives a car in reverse as well as anybody can forward. But in reality, when you're going 35 in reverse, that's tough. He's either an incredibly skilled and talented, almost stunt level driver, or he's almost hitting things, which is what's going on here. They pursue him, and he goes at one point accelerates toward Officer Tolentino's, Tolentino. Officer Tolentino's car nearly strikes him head on. He then accelerates in reverse westbound and turns into an alley. He's going again, the police estimate 35 miles per hour in reverse in the alley. And eventually he turns eastbound on Brown and drives forward and accelerates toward the armored Bearcat of the Tactical Enforcement Unit. At one point, the cops draw their guns on him and give him orders to stop the car, and he does. This all covers a relatively short period of a quarter mile. So it's short, but it's like all fleeings, and this one's almost even weirder. All kinds of police safety issues here. Police do find a white bag at the intersection of 34th and Lloyd filled with marijuana. They find another bag in the flight path. The different amounts are not big. One is 16 grams, and the other is 26, a little over 26 grams, so approaching, but not even an ounce. Totally more than an ounce, but again, these are not otherworldly amounts of marijuana or anything of that nature, but probably explains, I think, why the defendant was driving this crazily and dangerously. So I don't show a. Yeah, I don't have a. I don't show a record for the defendant before this case. Some context that really aren't even worth discussing, in my opinion, for the record. There's no basis for this point, but in that regard, I think that at this point, with all due respect, short jail time here for the defendant, given the lack of history, but recognizing the dangerousness of what he did is appropriate. Thank you.
And so thank you. Now, Attorney Dale.
Thank you, Your Honor. We're asking that the court sentence Mr. Newell to 6 months at the House of Correction to stay that sentence for a period of 15 months. The conditions of that probation can include an AODA assessment, 25 hours of community service, and sobriety. Mr. Newell comes before the court at 34 years old without a criminal record. He's born and raised in Milwaukee and still has a majority of his family still residing here. He currently resides with his sister and 2 8- and 7-year-old children. He also has 2 additional children who are aged 17 and 16, who he shares joint custody with and has from week to week. Now, he does pay child support for his oldest daughter, who is 17 years old, of $169 a month. And he has been keeping up with payments even during the pandemic, even though he does not have a full-time job. At the time of this incident, Mr. Newell was working at QPC temp service job, but during the entire term of the pandemic, he really has been surviving, and since he's residing with his sister, doing side jobs, doing lawn care, painting houses, anything he can really do that helps keep up with child support and take care of his children. Additionally, he does have a high school diploma and does have 1 year of business and management education from Bryant and Stratton, and a few months, I believe, at MATC as well. And moving to the gravity of the offense, Your Honor, this certainly is not the most aggravated plain case this court has ever seen with regard to the length and distance and the speed. Now, there are concerns with regard to Mr. Newell putting the car in reverse and driving at approximately 35 miles an hour. Certainly when I watched the video, there were no pedestrians out on the road. This did not take place at a time of day where there were significant people out on the road when doing the body camera footage. This took place on a Wednesday afternoon at about 5 o'clock in the afternoon. Additionally, what's important, I think, for the court to know is that also within the vehicle there was a passenger. When Mr. Newell eventually stopped, the police searched the passenger, and he's the one that did have marijuana in his pocket. Now that was approximately 1 gram. They also found 3 cell phones on that passenger as well. They did not find any marijuana on Mr. Newell. They also did not find any cell phones on Mr. Newell. Additionally, when police did find the baggies of marijuana on the street on 34th and the other street, officers in reports did not indicate observing any type of physical throwing action. The windows were closed when they stopped Mr. Newell, so it's not seen that Mr. Newell or the passenger had the opportunity to throw anything outside the window. Additionally, I'm not sure if any additional testing was conducted of the baggies that were found. I know that fingerprints were taken of Mr. Newell. They also took his DNA, and I'm assuming the charges came from that because they couldn't find any fingerprints that related to him or the passenger in the vehicle. So I think given all the facts and circumstances, this is not the most aggravated situation due to the length, speed, and time of day this did occur. I do think that Mr. Newell coming before the court without a criminal history, this is a felony conviction that's going to be on his record for the rest of his life. He's not even eligible due to the statute for expungement due to the lack of his criminal history to get that off of his record. So I do think due to the mitigating nature of this case, his lack of criminal history, that he is taking responsibility for his actions, that a probationary sentence here would be appropriate. The defense's recommendation also takes into account of adding an additional 30 days to the sentence that potentially he might have to face if he gets revoked, because the court would be giving him a chance on probation. So the defense does take that into account, but based off all the totality of the circumstances, I believe that Mr. Newell has taken this case seriously and that probation is the appropriate disposition.
Can I know, counsel, credit for time served? Any days?
7 days of pretrial departure.
7?
7, yes. And I did provide those documents to the court. I had reviewed within the health records.
All right, thank you. Now, Ms. Newell, is there anything you wish to say, sir?
On the job that I made and bad choice for my actions. And I just want to get behind me and try to do better with my life right now.
Some questions of you. Attorneys pointed out you have a high school education and you got 1 year of business college and also some schooling at MATC.
Yes, sir.
What was the MATC schooling?
Actually, I got with MATC right out of high school.
Okay,
That was my first. I had a different business, and it was just a longer distance of travel to get there, so I just transferred to Bryan Stratton.
and did you get a degree from Bryan and Stratton?
You know, sir.
What was the focus of your education there?
Business management.
Okay, thank you. Are you now married? Do you have any children in the world where you are the birth father?
For here in Milwaukee.
Okay, in the whole world I'm talking about. And as to those 4 children, how many boys, how many girls?
2 boys, 2 girls.
Okay. How many mothers?
Yeah.
No, how many mothers for these 4 children? 3 moms? Has paternity been established for all 4 of these children?
Yes, sir.
And was that done here in Milwaukee County?
Yes, sir.
And do any of the children reside with you?
Two, guns. And I get my oldest 2 week to week.
Can you get them when?
Well, week to week. Every other week.
And you now reside with your sister, is that correct?
Yes, sir.
Your attorney pointed out, well, you have some jobs through temporary services, but basically you've been doing lawn care and painting and other jobs during this coronavirus that we're having. Is that correct? Do you have any prospects for, on a longer term basis, for a job in a field that you want to go into?
Yes, right now, I've been working on trying to do like a garage open for cars. Like that's what I like to do, work on vehicles, so.
Okay.
That's my goal right now that I've been trying to focus on.
And you didn't have your own garage in terms of working at a garage. It's apparently pretty good jobs. Are you willing to do that as well?
Yes, sir.
In your judgment, is there an issue in your life with respect to the abuse of either alcohol or controlled substances?
Yes, sir.
All right, thank you for your input and that of the attorneys. Sir, you'll be sentenced on fleeing and eluding, maximum penalty 3.5 years and or $10,000 fine. You are a young man, 34, not a child, but you're a young man with the whole world ahead of yourself and all kinds of options. You have no prior record, and that certainly is in your favor. Expungement's not an issue, as your attorney pointed out as well. In terms of education, a high school education, initially went to MATC, took some courses, but then transferred over to Bryant Stratton. Did that for 1 year, and the focus there was on business courses for yourself. You're not married, you do have 4 children, 2 boys and 2 girls. There are 3 moms involved. 2 of the children reside with you and you take care of them. The other 2 children you have on alternate weeks or alternate weekends? Alternate weeks. So you are significantly involved with the children, and you state for all 4 children, paternity has been established. Is that correct? All right. Good work record. Since the coronavirus has impacted all of us, you've done some temporary service jobs, lawn care, painting, but the longer term goal you have is to do things in terms of mechanical work on cars. And whether you open your own garage or have your own business or you work for others, that's more the career goal that you want. It can be a very good career. You indicate there's not an issue here with respect to abuse of chemicals, including not just alcohol, but controlled substances. Your demeanor has been very good in court. In fact, you're a very articulate young man. You present yourself very well. Now, the offense itself here is one that really is outside of, 34, you hadn't done a crime before. It's outside of your past history. And it is an indication that, whoever this other person was in the car that had drugs and et cetera, but you created a risk. The other officers involved, if other persons weren't on the street, others were involved, but the other person in the car and yourself, you could have been hurt. And actually, in terms of officers, endanger them, you could have been hurt by them as well, and you weren't. The offense, given going backwards and the speed, maybe you're really a good driver, but that creates great risk to yourself and others and is aggravated. And you are fully culpable or responsible for the offense that occurred, all within a quarter mile. Public has a right to be safe, includes you, your friend. What is the name of the other person?
Christian Roby, R-O-B-Y.
Risk to Mr. Roby, of course, and to yourself. The law requires that I focus as well on your rehabilitation needs and the gravity of the offense. Given all the information that's been presented, I'm going to act as follows. You have no prior criminal history at all. I find that in terms of using the resources of probation for first offense, I don't see where there are particular needs. You're a good worker, you have good education, you have career goals, you're meeting your responsibility to your children. Really, you're not the prototype of the young man or woman who comes into this court at all. So what I'm going to do in this case, the order is as follows. Given the offense that has occurred, it's the order of the court to be committed to the House of Correction here in Milwaukee for a total of 60 days. You're to get credit for 7 days already served. That means 53 days have to yet be served. And so those 53 days, you are to have Huber privileges, so you can continue work if you have a job or work seeking. And that you're going to find the deputies can give you instructions as the type of things you need to do. So when you finally get to the House of Corrections, you're able to get out if you have a job as quickly as possible. You'll find the deputies are very helpful in that regard. In terms of reporting in, what date do you want to report in? Certainly. State have any issues on report in?
No, I mean, assuming your request.
I'm talking within 7 to 10 days.
Right, sure.
Again, today is the 13th of August. Council, what do you want for reporting date?
August 23rd by 5 p.m.
Certainly, your report not later than 5 p.m. on, what did you say, 23
August 23rd, 5 p.m.
23 to August. You understand that?
Yes, sir.
Now, in addition, obviously no fine is imposed, particularly given the coronavirus and you don't have a full-time job, but you are to pay the court costs, they're mandatory, and any mandatory surcharges. So we're clear during the course of this remaining 53 days, you're to make payment of those costs, whatever they are during that period of time. Do you have any question about what's happened now?
No, sir, this is all I can do.
Okay. Again, you're the type of person I would think a couple years down the road, you're going to be owning your own business and you still gotta work, but you're a hard worker. You should never, and you shouldn't associate with this other person. All right, excuse me.
23rd is a Sunday, and you report on the 24th on Monday.
Good point. We have the best clerk in the world here. That's a Sunday. Could the report in be not later than 5 p.m. on the 24th, which would be a Monday?
That works.
Okay, got that. And again, you'll find the deputies will help you. And there are certain things you can do before you get there to make sure you have a job, you can get out right away. Work with the deputies. They're your friends. Okay, thank you to the parties. Good luck.
Your Honor, would that include childcare release as well? I think that would be very important.
Certainly, Huber, work or childcare.
Thank you, sir.
The deputy will come right to you right now. Just wait. Counsel, you'll deal with the appeal rights?
Yes, I provide that to the court.
You're good on that. I wish I could remember as well as you do.
Judge, on a separate matter, Ms. Bunch responded with a file which I sent to, Jerome, but is that for her to sign?
Yeah.
Okay.